I know are going to be the source of a story.
But she's not denying it, so why do you impeach her?
Well, wait a second. The witness is testifying to facts. The jury is the judge of whether or not she's being truthful in the way she's describing this, the way she may be shading it. So it's all subject to impeachment. There is a nugget of argument, though, that I do want to address that I think is legitimate, and that is, here's my concern. I mean, I've been waiting for you and not hearing objection on points, and you're raising, and it has to be contemporaneous, but there have been times where there is a failure to recollect, and the proper procedure would be then to refresh the recollection. If the recollection is not refreshed, then the statement may be read for that purpose, or possibly it's a feigned lack of memory. I don't think that's the case. Now, eventually we may end up with the inconsistent statement anyway. I figure that's what's going on, so I'm not intervening. But there are some of these statements that are not actually inconsistent with what the witness has just said. But absent an objection, I figure, you know, I'm not gonna help you because we're gonna get there anyway. So it's more efficient for me to just let it go.
Okay, except, Your Honor, with all due respect, to some degree, I'm afraid to object because I believe that my objections on relevance and hearsay have been valid. The court's overruled me. I don't want to look like the lawyer that objects to everything in front of the jury to be consistently overruled.
Well, you're making the wrong objection sometimes, I would say, and other times I don't agree with you. I mean, the hearsay ones are either his admissions or they're clearly for state of mind. There hasn't been a
well,
good
how was Jarecki's statements to her not hearsay, Your Honor?
Jarecki's statements to her are clearly not offered for the truth. So it's all just a statement of a person out of court. It's not hearsay. It's an out of court statement offered to prove the truth of the matter asserted. Unless it meets each part of that, each element of that, I'm not going to sustain your objection. So I'm sorry that the objections you're making are not resonating. But unless you do object to a legitimately problematic question. And Mr. Lewin complained that I'm supplying the grounds for you, and at some point I do intervene to prevent something that I think is not appropriate. But that's where we stand, and I'm just letting you know that so far any motion to strike is denied. There's kind of clearly substantive evidence that's come in, and I think more is coming.
What I'm confused about, Your Honor, is this. She is answering the questions truthfully.
That's up to the jury.
That is okay. Whether a question is truthful or not that's for the jury to answer.
Okay, but
the question is if it is inconsistent, if it is not the same thing that she said previously, she may be confronted with that previous statement, so she may deny or explain it.
But he says, isn't it true that the last time you were here you said this? That's not asking that after she denies an answer. It's starting the question with the presumption that she's not answering it, Your Honor.
And also there have been prior consistent statements introduced. So she's not only did she say it now, but she said it when she testified previously, and that's also acceptable. So I have to judge it in the moment. It has to be a contemporaneous objection, but I'm just giving you a framework for how it ought to work and how it hasn't worked with this witness from your perspective, but I don't know what to tell you.
And I'm still confused, Your Honor, and I apologize because I try not to be dense, but how is it relevant evidence if the questions are, did you deliver the box? Yes, I did. That's relevant. How do you get to start impeaching her if she tells you I delivered the box? That's what we just heard.
We heard a little bit more than that. Mr. Lewin, you feel a need to make the record clearer?
No, the only thing I would say is just simply this. It's my approach, which the court understands within its discretion, to when I'm going to put up a witness that I think, and by the way, she's come in, as Mr. Oliver has before, and I believe lied. So it's not that I don't have, and the court doesn't have a record of what she said before. So what I choose to do, which as the court accurately pointed out, is my option. I like to diminish their credibility on the issues before I start asking them the the specific question that's going to be relevant. I'm absolutely allowed to do that. As the court pointed out, I don't know if it's off the record or in court, in my opinion, in my experience, has been that it's a more effective way of doing things because the jury is able to understand where the witness is coming from, who they are, what their biases are, before they start presenting what they're going to present. Now, as an offer of proof, counsel already knows they have the transcript from the last hearing. Now, where we're at right now, it's very similar to Doug Oliver. I start with this stuff, and now I'm hitting her with the substance. Do you know the next area that she's going to be hit with? The fact that she sent him $115,000 in a suitcase and then said she had no knowledge that it was there. The fact that she is saying she didn't know Mr. Durst was fleeing. So I have many things to hit her with, and I'm very confident, as the court's aware, Your Honor, you know, I do my homework. I don't offer things that I can't support, and I know the evidence code pretty thoroughly. So I appreciate that the court is allowing me to do my job, and that I'm doing that is in the way that it needs to be handled. That's all that I really have to say about it.
And Mr. Chesnoff, I do think that you're understating the significance of the substance of this, not just the impeachment. I think this is relevant and significant.
Which part, Your Honor?
No, I'm finding the part about what she's presenting with, first, the defendant's statements to her, and also the idea of this money that she's taking large amounts of money, and she shipped him money, and it was a bowling ball case or something. I mean,
Yeah, what the question is this,
Yeah.
Your Honor. If there's no nefarious purpose for sending the money, then why do you have to impeach her?
I think it is nefarious, Mr. Chesnoff.
If
It's very
can't-
nefarious.
They can't establish she had knowledge, Your Honor.
Well,
So it's all a bootstrap, Your Honor, as far as I'm concerned. I may be wrong, but you give me a chance to make my record. I appreciate it.
thank you, Your Honor.
You're welcome. Department 1 is adjourned.